The main points that I wanted to raise in terms of the agreement is how you get out, or what happens if you need to get out, and to the value of your shares. So I guess things to think about when you're drafting the agreement: can I just terminate at will? Is there a process that I need to follow, or how are the assets of the company treated and valued at termination, including your shares? Some of the most effective agreements will allow you to determine the sale and price of your shares. So often you'll find, if you are exiting or someone else is exiting, that this is a fairly common provision, that shareholders have to offer their shares to existing shareholders first before third-party purchases, which is called a right of refusal or offer clause. Then shareholders' agreement might contain some clauses about a third party wishing to purchase some or all of the company. So a drag-along right is where majority shareholders can actually require minority shareholders to sell, so that a bidder can buy the whole company. Otherwise, there's what's called a tag-along right, which provides that the minority shareholders can, I guess, tag along with a majority shareholder if they're wanting to sell. But as I mentioned, I guess that the most important thing, particularly if we're amicably divorcing our business partner, is what's the dispute resolution clause in terms of any disputes between multiple shareholders or shareholders and the company. This can be a really good trigger point for avoiding having to proceed as far as court, etc. It often sets out, and it should set out, how those disputes should be handled, whether the parties have to mediate within a certain period of time, what constitutes a dispute, and when the avenue is open for parties to proceed to litigation.